Whoops. There we go, folks. That's better. Welcome, everyone, to our daily live stream. I'm David Brannen, your lawyer here at Ask a Lawyer Live. I am a employment and disability lawyer at Resolute Legal Employment and Disability Lawyers, is the name of the firm. I'm here today to answer your questions about employment law. And at the end, I have a short presentation. And then at the end, we can talk about anything you want, mostly employment and any disability law questions where I'm good. But if you have other legal questions, I'll give it a shot and we'll see where we can get to. We come at you here every day, 4 o'clock Atlantic, 3 o'clock Eastern. We'll be back tomorrow again. Tomorrow is Thursday, so it's our call-in show. If you want to call in, the phone number to phone in will be available on the screen during the live stream. I can take your calls and do a more in-depth kind of consultation with you, but it is public. So if you have information that is private and you wouldn't want to share with me, you definitely don't want to do it on that live stream, but we can answer basic questions and I can get more details to give you a better answer. Friday, we have a special guest, Lisette LeBlanc, who is a lawyer at our firm. She does more mediations than anyone at our firm. So I'm going to be just talking to her about her experience with mediations in long-term disability cases, things that you should be thinking about as a client, the good, the bad, the ugly. We're going to cover it all tomorrow afternoon. I'll make sure that that is up on our YouTube channel. I think the time, it's going to be a different time on Friday. I believe it will be, I'm going to get this wrong. I'll double check before the end of the stream here, and it will be posted ahead of time when it's going to go live on Friday, but it's definitely before 3 o'clock Eastern. I think it will be around 1 p.m. Eastern, if I'm not mistaken. Okay, let's get into today. So today's presentation is on, let me bring this up here. Severance pay in Canada is what we're going to be talking about today. And before I get into that, if you want to ask questions, how you go about it is you just put your questions in the chat. If you're watching on YouTube or if you are watching on Facebook, just put your questions in the chat. Put a Q in front of them. You'll see this little scrolling bar here. It tells you exactly what to do. Put your questions in there. If they have to do with the presentation, I may answer them during the presentation. Otherwise, I'll wait and take all the questions afterwards. As many of you know, if you've been here before, the portion of the presentation that I'm doing will be clipped out and put on YouTube as a standalone video. So when I'm getting ready to start, I'll have to compose myself here and do a new opening for that, just so if you're wondering why is he introducing himself again. So you're kind of behind the scenes right now, helping me record some of these videos that we're going to have on the website. All right. So I don't see any questions before we get started. If you want to put in the chat where you're coming in from, where you're at in the country, I would love to see where people are attending from. The chat is public. I think other people, I haven't seen it on your side, but I do think other people can see the chat. So don't put any private things that you want to keep private in the chat. All right, let's do this. Hi, everyone. Welcome to Ask a Lawyer Live. I'm David Brannen, lawyer here at Resolute Employment and Disability Lawyers. Today, we're going to be talking about severance pay. And it's one of the most important topics for anyone who's recently lost their job. Whether you've been laid off, fired, for any reason, it's critical to understand what you're entitled to. And spoiler alert, it's usually more than what your employer offers you upfront. Let's dive in what we're going to cover today. I'm going to change the screen. Here we go. Let's do this. Okay, so what we'll cover today in the next 20 minutes or so is what severance pay actually means in Canada, the difference between minimum standards and full legal entitlements, what's typically included in a severance package from employment, the biggest mistakes people make, and how you can protect yourself and your financial future. And of course, after this presentation, I'll open up questions in the live chat, but if you're watching this afterwards, you can just put your questions in the YouTube comments and I will watch out for them. Okay, so what is severance pay? Let's start with the basics. Severance pay is compensation you receive when your employment ends, when your employer ends your employment. Now, there are two main parts to severance pay. The first part are what are called statutory entitlements. These are the bare minimums that you're entitled to by law. The second part are called common law entitlements. These refer to court decisions and are often significantly higher than what you are entitled to by the statutory minimums. You'll also hear terms like termination pay and severance pay. They're often used interchangeably, but technically they do mean different things depending on your jurisdiction. For example, in Ontario and in federally regulated workplaces, severance pay is a separate legal concept than termination pay. So if you are in Ontario or if you are in a federally regulated workforce, you can get technically termination pay and severance pay. Whereas in most other provinces, termination pay and severance pay are just used interchangeably to mean the same thing. So let's start with the statutory minimums. Each province in Canada and also the federal government over federally regulated workplaces, each province has its own legislation. These are laws passed by the province that outlines the minimum notice or severance pay required. For example, in Ontario, the Employment Standards Act guarantees 1 week of notice or pay up to 8 weeks. So your termination pay in Ontario is 1 week for every year that you've been employed, up to a maximum of 8 weeks total. So in Ontario, they also have something else called severance pay, where for larger employers, and if you have been there more than 5 years, there's an additional pay that you can get up to 26 weeks total. Okay. Sorry, up to 26 weeks in addition to the 8. So Ontario has a very generous termination pay and severance pay minimum standards, much more than any other province in Canada. Most provinces, you are only going to be entitled to termination pay, which typically is going to be up to a maximum of 8 to 10 weeks is where they cap out in Canada. And that would be for employees with 8 to 10 years of employment. Now, if you work in a federally regulated industry like banking or railway or something like that, then you are going to be covered under the Canadian Labor Code, which is different. And it does have better protections than some of the provinces, including having a severance pay, statutory severance pay, in addition to termination pay. But anyway, here's the key takeaway from this is that these are just the minimums and they're the legal floor and not the ceiling of what you can get. So most people are entitled to more than is offered or provided for under these minimum statutory requirements. Let's look at common law entitlements. So I've just told you about the statutory minimums. Common law entitlements are what courts would award you if your employer didn't give you proper notice, and there is nothing in your employment contract preventing you from getting notice beyond the minimums. So that's important to keep in mind. The statutory minimums, you're entitled to get them no matter what, but anything above that depends on your contract, your employment contract. Employment contracts can limit you to only getting the statutory minimums. But if your employment contract does not do that, or if you don't have an employment contract that's written out, then you are entitled to the full common law severance pay that would be available. So we're going to look at right now. So what are the common law severance entitlements? This is what the court would give you if your employer didn't give you enough notice or pay instead of notice for terminating your employment. When figuring out how much to give you, the courts look at several factors. There's quite a long list, but the main factors they will look at are things like your age, how long you were employed there, the type of job you had, your position and responsibilities, and how difficult it will be for you to find similar work. Now, there are other factors as well, but those would be the basic factors that a court would consider. So generally speaking, the older you are, the longer you've worked there, the higher your position and responsibilities and pay, and the more difficulty you would have in finding alternative work. Those factors all result in you getting a higher amount of severance pay than someone who is younger, who hasn't worked there very long, who has a lower level position that's easy to go find that similar job out in the economy. That person would get a lot less in terms of their severance pay. So for example, like a 25-year-old with 1 year experience in an entry-level job might get 1 to 2 months of common law termination pay. But a 55-year-old manager with 10 years experience who was a manager, it could be entitled to upwards of like 12 to 18 months of termination pay at common law. So there's a huge difference there to keep in mind. And this is one area where employers may only offer you the bare minimum when you could be entitled to much more. So for example, the 55-year-old manager I spoke of with 10 years service in Ontario, they would be only entitled to 8 weeks of statutory termination pay. And possibly if they worked for a large company, they could get 8 weeks plus another 10 weeks of severance pay. But even if you added those together, 18 weeks is much less than 12 to 18 months of pay. So you can see the huge discrepancy there on whether you're getting paid the statutory minimums or you're entitled to common law. Okay, so what is included with severance pay? There's a bunch of things here. So it's not just about your base salary. A proper severance package can include many things, including your regular pay, bonus or like incentive pay that you may get as part of your employment, benefits continuation, so continue your benefits for a certain number of months into the future, pension or RSP contributions going forward for a certain period of time, commissions and car allowances, anything that is part of your compensation package can be included as part of a severance package. Severance can also come in different forms. It can come as a lump sum payment, which you would get all at once. It can come as a salary continuance where basically you continue to be paid on the payroll just as you have been and nothing would change. And a third way that is people are often caught off guard by, but it can be done by working notice. Working notice is where your employer just gives you a heads up that, oh, by the way, your job is going to end. We're terminating your job. They have to be very specific about it. We're terminating your job on this date 6 months down the road. So keep working, but know that on that date, 6 months down the road, your job is going to end. That would be the equivalent of giving you 6 months pay and laying you off today, terminating you today. So keep that in mind. Employers can they're able to do that. They can give you working notice and have you continue working, but telling you definitely your job is ending on this date. Now they have to be very specific that it's going to end on this date. And they have to put it in writing to you for the most part for proof. But if they do that, the working notice will be sufficient and you wouldn't be entitled to pay beyond that unless the working notice was not enough notice. That was what it would boil down to. So the details really matter because how you get the payment and what form can affect things like taxes and benefits coverage. And so you want to keep these things all in mind when you're negotiating a better deal for your severance package. All right. So common mistakes that we see people make and traps and how you can avoid them. One thing that is very common is if you are dismissed from employment, the employer knows that they have you in a real vulnerable position. Your rug has been pulled out from you financially. You're not sure what's going to happen. So they will make this offer. They will make offers to you with very short deadlines for you to do something. Like saying, here's your offer. You have until Friday to sign it or it's gone or something like that. That puts a lot of pressure on people to sign quickly because you're worried about, I got to make the rent next month. So it puts pressure on people just to sign because you're afraid that the employer is going to take it away and you might not get anything, or you might be delays and these kinds of things. Now, even though they pressure you, you don't necessarily have to sign right away, but just keep that in mind. A mistake would be to sign immediately because the employer is putting a lot of pressure on you. Now, another thing is some people are trusting of their employer and they just assume that the severance offer that's been made is probably fair. But quite often, severance offers, sometimes they're more than fair. I've told people like, this is very fair offer from your employer. I can't believe it. Other times, though, they're usually either at the bottom end of what could be considered a fair offer, or they're below a fair offer. That's usually what you're going to see. Lawyers who are doing this strategically for the employer will try to pick a number that is as low as possible that makes it unlikely that a person will get a lawyer and sue. So there's this sweet spot for the employer where they can make a lowball offer that's still high enough that it makes it unlikely someone will get a lawyer and sue them. So that is the where a lot of employers go. Although some employers will give very good offers. I've had to discourage people from doing litigation and things because the employers made such a good offer that it's not reasonable to think that you could improve it on litigation. All right. Now, another thing is not reviewing your employment contract, accepting an offer without reviewing your employment contract. As I said earlier, some employment contracts can limit your right to common law severance, and the wording can be in there, but that wording is very particular, especially in the province of Ontario for the most part. In Ontario, they're very particular. The courts are very particular on how the wording is around these clauses in contracts denying people common law notice pay. So if it's not worded perfectly, and this is one of the areas where it's usually these kind of like wording mistakes go against you, the consumer. This is one where the wording mistakes go against the employer. So if it's not worded properly, then the courts will void it out, and you, instead of getting these limits on your termination pay, it opens you up to common law. So just don't accept it if your employer is asserting that you are not entitled to common law compensation. You should get a lawyer to look it over just to be sure, to make sure that any termination clauses you have are valid. The other thing is that your employment contract itself may not be valid. For example, a common trick is for long-term employees, at some point, the employer may realize, oh, I never got an employment contract with them in writing. So they'll present you with one at some time and just say, you know what, you need to sign this. This is your employment contract. Please sign it. So they can force people to sign these contracts, but not really give them anything new. Those kind of contracts can be held to be void because they're not properly formed as a contract. You already had a contract. You can't impose a contract on someone without them giving something new and getting something new in exchange. And so you maybe in your mind think that I signed that agreement, but that agreement might be void. Again, you need to check with a lawyer on that before you make any kind of rash decisions, but that is something to keep in mind. So deadlines are another thing that goes very close to signing quickly. So signing quickly is a mistake, but letting deadlines scare you is also a mistake. These are often like a paper tiger, these deadlines that they're putting on you. They're just simply negotiating tactics, and they're kind of distasteful because the employer knows that, and their lawyers know that you're under a lot of pressure. So they are taking advantage of that, but don't let deadlines scare you. You have time. You can get things extended. You have rights. Speak to a lawyer, and then they can let you know more about your situation and tell you if you really, some deadlines can matter. So a lawyer can tell you if the deadline matters or if you can just ignore the deadline or ask for an extension of the deadline. The bottom line is don't act out of fear. Get advice so you can make the right decision, because this will have a long-term impact on you. And once you sign off on these deals, if you wake up the next day and realize you made a mistake, you probably will not be able to undo it. So how do you protect yourself? Well, I've sort of covered that, but I'll just go over it again. So you don't want to rush. Take time to understand your rights. Now, don't sit on and wait forever, but act quickly to get advice from a lawyer or to read up online or go to ChatGPT or whatever you're going to do to try to understand what's going on. Take the time to do that before you sign anything or make a final decision. A big thing you can do is to get a copy of your employment contract and review it and have it reviewed by a lawyer to fully understand what the limitations are for severance pay or what you may be entitled to. Again, do not take at face value that things in your contract necessarily will apply or that the contract itself is valid when it may not be. It's okay to ask questions of your employer and to try to negotiate the severance package with them. It's rare that they give you a take it or leave it severance package. Often they're expecting some pushback and they build that in to leave room to negotiate with you and pay a little bit more. So that's often built in. It's understood that this is something that could be negotiated, and they will pay more usually than their first offer, almost always. And get advice before signing anything. Ask questions. I'm just looking at my notes here. Yeah. And I will say that if you feel like you were rushed into signing something, like for example, say they bring you into a room and say, we're terminating you today. They slide across the table. Here's your severance offer. Here's the check. Sign right now, and you can take this check and leave. Like that level of pressure, that a court might undo that, something like that. If you wake up the next day and realize you've kind of been hoonswaggled here and in the heat of the moment with them pressing the check and pointing, and that kind of thing could be such an undue pressure put on you that courts could undo something like that. So if you ever find yourself in that situation, but you would need to act quickly, talk to a lawyer and see if that can, something like that can be undone. But it's hard to undo things where you had, certainly if you had legal advice or took a long time to consider it, it's much harder to undo a deal like that, even if it was an unfair deal. All right, let's think of some final thoughts here. So I would say some of the key things are that you often have more rights than you think you do. So just keep that in mind, that there's a good chance that you are entitled to a lot more than is being offered to you. Now, your employer usually is going to start with a lowball offer with the idea that they will pay more. So it's important to build that into negotiating with them. Get advice before signing anything to make sure you don't leave money on the table. That's the phrase when you could have paid, you could have gotten more money. They had more money to pay, but you didn't ask for it, so they didn't give it to you. All right, thanks for joining me. If you are watching live, just put your questions down in the chat. I'm going to be happy to review them now. If you're not watching live, you can still put your questions in the comments. Sometimes I'll be able to respond to those. Or if you're not watching live, you can show up to one of our live sessions that we do each week. Okay, so that is the end of the recording for that. Now we can jump back into our local audience here. I'm going to just come back up on the screen here. Here we go. Here we go. Live Q&A. So looks like we do have some questions here. So Yusuf is asking, give me good keys to use in arbitration, please, as discrimination disability was terminated. This is something, Yusuf, I need to know a lot more information to be able to give good advice on what you could do. It sounds like you have an arbitration and discrimination. So it sounds like there might be an arbitration over losing your job because of disability discrimination. So in those cases, like it would depend on what is actually happening with your case on the keys to it. But generally speaking, if you're going to an arbitration, it's very important to have evidence and proof of the discrimination, and to also be very clear with evidence on what your income losses were, how the disability discrimination affected you kind of mentally and affected your life. And you would also want to have evidence of what efforts you've made to try to find other employment and things like that. Those would be kind of general things. And okay, here's a follow-up. My other question is why a lawyer can't represent the worker involved in a union. Okay, so here that's very important. So if you were involved in a union, you do not have the right to hire your own private lawyer. That is because one of the good and the bad, the unions have good and bad parts about them. One of the good things is that you have collective rights. But one of the bad things is that by allowing you to collectively negotiate against the employer, the individual employees give up their rights to bring lawsuits directly against the employer. Okay. That's part of what you lose as being part of a union. You gain other things, though, from being able to bargain collectively. So what that means if you're in a union is you cannot hire a lawyer to sue the employer yourself. You have to go through the collective bargaining process. That includes using your union representatives and going through whatever process is set out in the collective agreement for arbitration. So if this person was talking about arbitration, now this makes sense that if you're in a union, you would be going to an arbitration. That means you're not allowed to go to the courts. So your arbitration over your employment dispute would be done by an arbitrator who is usually a lawyer who is appointed as sort of like a judge to make a decision in the case. So you and your union representative would present your side of the case to the arbitrator. Then the employer and their representative and the employer lawyer would present their side. And an arbitrator is someone who does make a decision that is legally binding on both sides, just like a judge would do. And so that basically explains why you can't go get your own private lawyer. You have to go with the lawyers from the union. Again, most times this is going to be good for employees, but it is true that the interests of the individual employee do not always align with the interests of the union itself or the employees as a group. So just keep that in mind. Okay, I think I answered this one. Why can't the lawyer represent the worker? It's really because of the collective agreement, and the collective agreement prevents individual workers from hiring their own lawyers or from filing lawsuits against the employer. So if you're in a union and you just say, I'm not going to listen to that, I'm going to go get my own lawyer and file a lawsuit. If you did that, the union's lawyers would go to court and they would successfully be able to have the court dismiss your lawsuit for a lack of jurisdiction, is what would happen. Okay. I'm not sure if people have questions. I've got a few others here I can kind of cover. Something that often comes up is if you've been let go from your employment, you've been terminated, what happens with EI? So let's just say you're terminated under no fault of your own. They let you go. They've offered you severance. Well, you are also entitled to be able to get EI. EI is employment insurance. You can apply for that. You wouldn't qualify to get EI until if you're getting paid out like benefit sort of termination pay for your employer, the period of time that you receive the termination pay, you can't get EI. But once that runs out, EI can kick in and you can then get EI going forward. A common thing that can happen is the employer may agree to pay you the 4 weeks you're owed of statutory pay, but they're refusing to pay any common law pay after that. Or you're disputing what the amount of common law pay they're offering, so you don't get it. The employers will pay out the 4 weeks of statutory pay right away, and then your EI can kick in after that while you're still kind of negotiating the common law severance pay. However, one thing to think about is that you have to pay back EI. If you get common law severance pay, you have to pay back EI dollar for dollar from that money if the common law severance pay is for termination pay. Now, there are other damages. I didn't go into a lot of the other damages that can be paid, but there are other damages you can get as part of a lawsuit over a wrongful dismissal. That don't directly relate to severance pay. These could be things like aggravated damages, punitive damages, human rights violation damages. Those types of damages, depending on that, if they're set out properly, they do not necessarily have to be paid back to EI. So just keep that in mind. But if you get termination pay, definitely that kind of pay has to be paid back to EI. So that can also make it uneconomic to get a lawyer because you will, as I go to my next question here, with income taxes, you will pay income tax on the portion of any severance that relates to termination pay, common law termination pay. So if you're in a situation where you are on EI, you're negotiating a termination pay and you've got a lawyer, well, now you're in a situation where any termination pay you get, you have to pay taxes on it. So they take off the tax money. Then you have to pay back EI, and then you have to pay a lawyer. It is not uncommon in these situations that can mean that you get nothing. So literally you would be suing for your employer to get paid, pay back EI, and you would really come away with nothing. That is a scenario that can happen. So this is why you may have trouble finding a lawyer to take on your case, because it can be just impractical to sue based on the fact that you're going to get back. You're going to have to pay back EI. You're going to pay the lawyer and then pay taxes, and just there could be nothing left over for you to get. And so why would you want to do lawsuits and go after a company when it's not going to result in any money back to you? Now, that's not going to be the case in all situations. So that is something you'd want to talk over with a lawyer on whether it's practical to do a lawsuit in your case. All righty. So we have another question here. What if what comes out in arbitration is unfair? Do I have the option to sue them, or can I judicial review? As most arbitration, I believe, won't be fair. So that's a good question. You can appeal arbitration decisions for judicial review, or whatever process, I should say, whatever process is set out in your collective agreement. But there is a process of appeal, but it's very limited. You definitely cannot sue them. So you absolutely cannot sue them. You can go for a type of judicial review depending on the process, like following the process set out in your collective agreement. But I would really caution you that there is very low chance of success with that type of appeal. The courts that do the reviews will give a lot of free, they call it deference, but they give a range of outcomes that they allow to the arbitrator, even if the court might disagree with the result. As long as the result falls within a range of acceptable results, even if it's different than what the court would do, the court will defer to the result of the arbitrator. They want to allow these arbitrators to be able to make decisions and not be second guessed over everything. So unless the arbitrators made like a real bad error in applying the law, then was very unlikely to get overturned on a judicial review. They're going to give a lot of deference to these arbitrators to make the decisions, and you definitely can't sue the employer. Here's one that comes up as well. So sometimes you have a mixed case where you've been terminated from employment, but the reason for the termination may have a discrimination kind of element to it, or that you were discriminated at work leading up to, and maybe that led you to quit the job because of discrimination. The discrimination come in many forms. Common ones we see are disability, like that is, we do employment and disability law. So our real wheelhouse is when we're doing employment cases involving disability. Those are the majority of employment cases that we handle. And if there has been disability discrimination that is mixed in with your termination, that gives you a much stronger case in terms of the type of damages you can get. Because now, in addition to the termination pay, you are looking at getting aggravated damages for mental distress, possibly punitive damages in really extreme cases, and compensation for violation of your human rights. In Ontario, you can actually file them all under one lawsuit. So you can file a lawsuit that has all the elements to it of wrongful dismissal plus human rights damages and all these things. In other provinces, it's not as easy to do that. You might have to do multiple different judicial proceedings. So, for example, it's not uncommon in Nova Scotia or New Brunswick that we would file a lawsuit for wrongful dismissal and at the same time file a human rights complaint. What will usually happen is the human rights complaint will go on. They will just put it on pause pending the outcome of the litigation. However, the employer now knows they're dealing with both. So if you are reaching settlements with the employer, they will now have to take into account that there is both of these claims out there, and that is a way to get payment for the human rights damages and things. So keep that in mind. When we're looking at, like, we can't take on every case of every person that contacts us, not even close. Like, we get contacted by hundreds of people a week, and we can only take on 1 or 2 new cases a week just because we're a small firm. We don't want to be a big firm, so we're very selective on the cases we can take. We always look for cases involving disability discrimination are our ideal cases for employment type cases. So if you think you might have an issue like that, you could always check with us. It doesn't mean we won't take on other cases depending on our availability for new cases to come on. They don't always have to involve discrimination or disability discrimination. We will take on cases that involve just other types of discrimination. For example, I don't think we took the case on, but it was very close that we would like to take the case on, was a recent one of discrimination around, it's called family status. So that is people being fired because of their childcare obligations, single parents. So we will take on cases where single parents have been fired because basically because it's inconvenient for the employer to have the childcare arrangements that the parent has. That could be like not allowing them to leave work at a certain time, It has to be reasonably negotiated with the employer, but they do have an obligation to accommodate you in order for you to meet childcare obligations, as long as it's all reasonable and can be done within the context of your job and employment. All right. Do we have any other questions? Lots of good questions here today. Nope, it looks like we don't have any. I am working on I don't have it done yet. I am working on a book. So I have books on disability. I have a book in the works on step-by-step guide to wrongful dismissal in Canada. So similar to my step-by-step guides that I've done for long-term disability, will just take you through what things you need to know when you've been wrongfully dismissed, how to interact with the legal system and lawyers. It'll explain compensation and that kind of thing. So that book is in the works. It's kind of just been held up because of other things we have going on. My big push right now is to get a new version of our website out. Hope that was supposed to be done by the end of this month, and I'm not sure I'm going to be able to meet that deadline, but we have a new version of our website coming out, and so that's really eating up a lot of my time right now. Once that gets done, though, I will shift gears and go back to try to finishing this book. So just keep that in mind for the future. We'll be back tomorrow with talking about, tomorrow's just an open day, so I'll just take calls from people, or if people don't want to phone in, we can just do the questions through the chat as we're doing today. And again, like I said, I'll see you on Friday with Lisette, who will be here talking about mediations. I think that's all for today, folks. I'm a little tired out. I've done 2 presentations today. I spoke earlier today for an hour presentation for the Fibromyalgia Association of Canada. They're a great bunch, and I'm always happy to speak with them. But a 2 presentation day is always tough, especially sort of like if you have a court hearing, it just drains the life out of you. So I am going to go relax and sit down a bit, let my brain rest. I'll see you all back here tomorrow. I wish you all the best. Take care.